Morning everyone. Today on the webinar we have Fieldfisher, also known as Flick, who's a partner in our privacy team. We have Paul Lenoy, a director in our privacy team, and myself, Joe Bates, a director in the corporate team. Today we are going to cover privacy issues in an M&A context, but before we launch into all the privacy fun, I thought it'd be helpful to do a brief summary on what the differences are between an asset sale and a share sale. Before I do that, we may not have time to answer questions today, but please send any through and we will follow up with you after the webinar. So the differences. Basically, the most important is the outcome. A share sale results in a clean break for the seller. So the buyer purchases the company, including all of its assets, liabilities, and obligations, even though those the buyer may not know about, which is why often the buyer will seek extensive warranties and indemnities in the SPA. Whereas in an asset sale, only the agreed assets and liabilities will transfer to the buyer. So you may have heard the phrase cherry picking what assets it wants. The seller retains ownership of the company and any assets or liabilities not transferred. The sale process is also slightly different. In a share sale, the business continues as a going concern. There's no need to notify employees, customers, or suppliers in the early stages, but due diligence is generally far more involved and often very costly. While due diligence in an asset sale will be less intensive because legal ownership of the relevant assets and liabilities must be individually transferred or assigned to the buyer. This part is the time-consuming element. It makes it difficult to keep the sale quiet early on. Another thing to consider is the third-party contracts. Generally, in a share sale, there is no need to get consent to transfer third-party contracts to the buyer, unless, of course, the contract contains change of control provisions. The contracts remain in force with the company that is being bought, whereas in an asset sale, consent to assignment or novation will need to be considered. Employees in a share sale, employees' contracts remain in force in a share sale, and there is no need for consultation under TUPE. No surprises that under an asset sale, TUPE is highly likely to apply to the employees of the business. And finally, tax. We don't have time on this webinar to go into the numerous tax considerations, but the one piece of advice I would give you is that tax is really important and to get your tax advisors involved from the beginning. So that's a very short and quick summary of the key differences, but in reality, we see far more share sales than asset sales these days, and the main driver for that is tax. So enough about me talking about the corporate side of things. Time to get into the more interesting stuff. Privacy. So starting out with Flick, if a company is considering selling, what are the top few things they should look at doing ahead of time in relation to privacy to get themselves match fit for a sale, or otherwise have their ducks all lined up in a row?
Brilliant. Well, yeah, hi everyone. For those of you who have signed into our webinars before, thank you very much for coming back, and we hope you find this one really useful. And Joe's already covered some of the housekeeping, but I just also wanted to mention that if you do really enjoy this webinar, we've now got this fantastic YouTube channel where all of our previous webinars are available, so feel free to go and visit that, and please get us our, like any of the previous ones we've done, because we're trying to get our YouTube channel to gain some traction. But okay, so turning to the question of what you need to think about if you're trying to get your company ready for an acquisition from a privacy perspective. So I find this an interesting question because I, as a former kind of tech transactions lawyer, used to do quite a lot of corporate support. And when I say corporate support, it was helping brilliant corporate lawyers like Joe do all the due diligence as part of a kind of, as part of the M&A deal. And I recall back in the day that privacy did form a part of that due diligence exercise, but was kind of a relatively small part of it. There were a few questions focused on data privacy, principally focused around testing whether or not the potential target, had addressed any notifications that needed to be made to the regulators, whether or not I'd suffered any breaches or there were ongoing complaints. And really, like, it was pretty basic. Does it have a privacy policy? What do the contracts say about privacy? So I would say compared to what we're seeing now in terms of privacy due diligence, it was pretty lightweight back in the day, relatively speaking. But now, because privacy has gained a huge amount of traction, particularly since the GDPR has come into effect, and we've had the GDPR for a year now, it's raised the risk profile of not complying with privacy, requirements. It's really become much more of a focus for the due diligence process, and as a result, it really, we know that buyers want a comprehensive understanding of the data privacy and security profiles of a target these days. So with that in mind, if you're thinking about getting your company ready and in shape for a potential deal, I think one of the starting points, anticipating that you're going to be subject to what is effectively a much more rigorous audit of your privacy compliance, is to make sure that you have done some kind of data mapping exercise. And actually, M&A issues aside, a data mapping exercise is the practical start for any privacy compliance project. Know what you've got, know what you're doing with the data, know who you're sharing it with, the purposes for which you're processing it, and the legal grounds you're relying on. So if you're a data controller, we know you have to have legal grounds to process the data. Are you able to articulate, what you're doing with the data? Do you have a good sense of who you're sharing it with, and what transparency you provided to the underlying data subjects? You are going to get asked all of those types of questions as part of any due diligence exercise. So you need to have your ducks in a row in terms of understanding your data processing activities and having that centrally documented somewhere in some kind of accessible data map that you can share, because that's one of the things that's going to be asked for as part of the due diligence exercise. So once you've established and you can articulate what you've got in terms of data, the next really important piece is to do some of that important window dressing from a compliance perspective. When I talk about window dressing, I mean, what messages are you externally putting out there to the world in terms of your privacy compliance? So what does your privacy policy say about the data that you're processing? Is it comprehensive enough? Does it fully articulate all of your data processing activities? And does it walk and talk the GDPR transparency requirements? So that document is going to be a really important window into your privacy compliance program. So make sure that it fully addresses the GDPR requirements, that it's accurate, that you're not making statements that you can't actually live up to, and that it basically has everything that somebody who's going to be looking at your company wants to see and should expect to see in a good GDPR compliant privacy policy. And then there's the kind of contractual piece as well. So what do your customer contracts and your employee contracts, if you've got European employees, do they address the GDPR compliance requirements? And then I think that there's three other really important things to get right. Data export. So if you are transferring data globally, European data globally, do you have an appropriate data export mechanism in place to facilitate all of those data transfers? That's going to be a really important piece to have in place. The other one is security. And Paul is going to talk about a little bit more about this because, spoiler alert, the next question is going to focus a little bit more on the specifics of what the due diligence will cover. But making sure that you have appropriate security measures in place and that you can articulate what your security program includes, because that's going to be a real focus for anybody looking at the value of your company, is to check what security measures you have in place. And then it goes without saying, if you are if the value of your company is really the data that you have, you need to make sure that you have a legal basis to process that data and that you've addressed, in particular, things like your transparency obligations. So all of that should kind of reveal itself in that data mapping exercise that I talked about as one of the first things you should be doing. Because if you, under interrogation, cannot prove that all of that data, which is really the reason why someone wants to purchase your company, that you don't have legal grounds to process it, that's going to be a real buzzkill for the deal. It's going to really undermine the value of the company and the data that you have. And then finally, just the last piece, if you say have a year to get your company ready for GDPR compliance, make sure that you have a plan, that you've got a list of actions that you want to get in place and that reflect some of the things that I've just discussed, to kind of get that hygiene level of compliance in place, and then track the progress of the actions that you're taking. Because when it comes to due diligence exercise, you want to disclose where you're at with your GDPR compliance program, and having that strategy and being able to articulate what you've done to address compliance will be really useful.
Thanks, Flick. So Flick gave the spoiler there, so it comes no surprise that the next question for Paul is focusing now on the buyer. You're in the due diligence process. What are the key things you are looking out for from a privacy perspective during the due diligence to decide whether you want to purchase the company or not?
Thank you, Joe. I would say that in relation to the due diligence investigation, which needs to be conducted by the acquirer, you should consider at least the following questions. You need to first understand the organization that you're buying. So to what extent does the target company gather and use personal information? Is the target company a data controller or a data processor? What is the legal basis used for processing? Is it consent? Is it legitimate interest? Is it something else? How does the governance structure look like? Is there a DPO in place? You need to understand as well, what kind of notice is provided. Is this in line, with the requirements of Article 13 or 14 of the GDPR? Has the target company made any commitments, any representations to its users and customers in connection with privacy and security issues? And then, does the target company have in place a process in relation to data subject rights requests? What is the typical volume of requests that they receive? In relation to cybersecurity risk, what are the particular types of privacy and cybersecurity risk of the target company, given its industry sector, geographic reach, the nature of its products and services, and so forth? Do you have a clear understanding of the target company's network, its system architecture, its data flows? Do you understand, its use of cloud providers, any third-party applications as well? What is the data retention and the deletion policy? Does the company transfer data on a cross-border basis? Will the acquiring company need to obtain any consent, or will it be subject to notification obligations to the use of any type of information from the selling company post-closing? What are the security practices of the target company? Does the target company have a written security program that meets current industry standards and best practices? Has the target company experienced any prior incidents, including data breaches? How has it responded to such incidents? Has there been any complaints, any regulatory investigations? So, this is just a sample of some of the consider when you conduct your due diligence. One other question that I would like to add as well, even though it's not privacy related per se, but it's really important nowadays, is the use of open source software. Many software engineers and developers nowadays, they use open source software, or otherwise they incorporate such software into the work when they develop products or technology. But then the use or incorporation of open source software by a selling company can potentially lead to ownership, licensing, and compliance issue for the acquiring company. And therefore, it's important to identify and assess whether there is any open source issues early in the deal process. If there is any pre-close sharing of data taking place, then a data transfer agreement will need to be put in place. Typically, this will be on a controller-to-controller basis and cover the acquiring company's obligation around the handling of such data. For example, this would mean that the acquiring company will need to comply with applicable data privacy laws. It needs to make sure that it puts in place appropriate security measures, notification of security breaches, destruction of the data if the acquisition deal does not close within a certain time, and so forth. Now, some of you may say, well, this is a pretty long list of questions to consider, and why does it matter? What are the real world risks associated with that? And interestingly, there was a survey which was published yesterday, so 24th of June. And this survey was conducted by Forescout Technologies on the role of cybersecurity in M&A diligence. And in relation to the survey, so you had over 2,700 IT and business decision makers, which were surveyed across the United States, France, the United Kingdom, Germany, Australia, Singapore, and so forth. And the survey found that 53% of the respondees reported that their organization encountered a critical cybersecurity issue or incident during an M&A deal. And the cybersecurity concerns, which were discovered after the deal took place, often present risk which would have been factored into the negotiations, or may even have led, to the deal to be terminated. Still according to the same survey, you had 65% of the respondents who experienced buyer's remorse. They regretted the deal due to cybersecurity concerns. So, this is, a very important point to consider, in today's world where you hear about data breaches and so forth, left and right. And just to give you another example of how important the issue is. So in July 2017, you had a anti-malware vendor, Avast, which acquired another software company called Piriform. And Piriform was a developer of a software solution called CCleaner, designed to clean up unwanted files from personal computers and workstations. What happened was that, unfortunately, before the acquisition took place, Piriform systems were compromised in March, and it was only a few months later, in September, so 2 months after the acquisition took place, that the researchers at Avast noticed and discovered the cybersecurity incident. So what happened was that hackers managed to get their hands on stolen credentials to be able to access a developer computer. They gain access to development and distribution systems, and then they use that to infect the software updates of CCleaner, the product software, so that the malware was then distributed to over 2 million customers between August and September 2017. So the hackers, they implemented a backdoor so that these hackers could gain remote access to infected computers. And they use this, to gain access to large technology and telecommunication companies using the software around the world. And so, these incidents show that, companies of all sizes can be affected by privacy and security issues. And, while the full extent of the harm suffered by the affected companies may not be fully known at this stage, the cost, the business disruptions, the reputational damage could have been avoided had the issue been discovered during the due diligence stage before the acquisition took place.
Cool, thanks, Paul. I just wanted to pick up on one of the points that Paul flagged, because we get a lot of questions around it, and that's the extent to which you can share data with the potential target prior to the acquisition taking place. So one of the things to really flag here is that you can't assume that you can just automatically share certain data with the buyer. So, for example, if you have agreed with your own customers that you would be a processor of the personal data that you process on their behalf, that usually means that you've made some promises in your customer terms that you will not share the data with any other third party without the customer's prior consent. So it's going to be far more difficult to share data for which the target is a processor prior to closing, and usually you would only, usually want to ensure that only test or dummy data would be shared at this stage to the extent you're a processor. Sometimes the product and engineering teams on the purchaser side will absolutely insist they need real production data to carry out some sort of pre-close integration work. And at that point, it's frankly a bit of a commercial risk, and you'd have to discuss it with your privacy team to make sure you're putting in place to minimize some of that risk. But that's one really important thing to flag. The other one is, to the extent the target, are a controller of the data, then, as Paul mentioned, you need to make sure that when you're sharing the data with the purchaser, and usually that would be shared via some kind of virtual data room, then you need to make sure that you've put in place some measures to ensure that you're only sharing the absolute minimum amount of information that the purchaser may need at that point, that you've established that you have legal grounds to share the data with the purchaser. And typically in an M&A context, you're looking at reliance on your legitimate interests or the legitimate interests of the purchaser in kind of testing out whether they want to proceed with the acquisition. But if, for example, you've got sensitive personal data, and I'm thinking more around the employee HR type data, if you've got sensitive data that you need to share pre-closing, then you're probably going to have to get the consent of the employees. So that's something you would have to think about. The next thing is if that data is going to be shared with the purchaser and that purchaser is outside of Europe, or it involves some kind of data export, then as Paul hinted at, I think you're going to have to make sure that you've got an appropriate mechanism to transfer that data in compliance with European data export laws. Typically that would be controller to controller model clauses, or to make sure if it's a US based purchaser that they've committed to privacy shield assurances. And all of that would need to be addressed in a contract, in a data sharing contract.
Thanks, Flick and Paul. So the seller has decided to sell, the buyer through its due diligence, it's progressing well. So we now turn to the M&A agreement. So as Paul alluded to, any M&A negotiation is really just an allocation of risk. So Flick, what would the seller want to see in an M&A agreement versus what would the buyer want to be seeing in the M&A agreement? What is that negotiation or balance of risk that they're each vying for?
Yeah, so it's the usual tussle over the scope of the warranties and representations that are provided. Obviously, if you're acting on the buy side, you want to get as many assurances that the seller is GDPR compliant, or as close to any kind of firm assurance that you can get around that piece. You'd also want to make sure that they're repping and warranting that they haven't got any, large claims or data breaches that they, might result in you sort of basically purchasing a whole load of risk and regulatory exposure there. But one of the things to flag, if you are the seller, you're often, I keep seeing these kind of requests for that rep and warranty from the purchaser that you, the target, are absolutely GDPR compliant, and they want a kind of firm rep and warranty to that effect. And I don't know anybody who could stand behind a rep and warranty that they are 100% GDPR compliant. So be careful in the M&A agreement around sort of providing that level of assurance, and ideally, as in any kind of commercial context where you're being asked to say that you're GDPR compliant, I think it's much better to couch it in or condition it in sort of terms that say, look, we have taken reasonable steps to be GDPR compliant. We've disclosed the steps that we've taken. And then ideally, you'd put the onus on the buyer to satisfy itself that the target's measures are adequate, comply with the GDPR. Whether or not you can get to that position is a matter to be commercially negotiated, obviously. If you're still working through your compliance, making sure that you've disclosed the project plan, identified what steps you've taken, what remain outstanding, and make sure that that remains, that's something that is disclosed against. And then the other thing is, you're often asked to, provide assurances around, security incidents that may have happened within the company. And it's making sure that whatever definition of security incident is used in the M&A agreement, that it aligns with your internal definitions to ensure that there's no gap there in terms of the assurances that you're making or the information that you're disclosing around the breaches that you could have had.
Cool. So we're on to now, the deal is done. So after a few celebration drinks and probably catching up on a lot of sleep, you must make sure that someone is taking care of all the privacy elements post-acquisition, i.e. don't just file the M&A agreement away in your drawer and forget about it. You've really got to think about what do we need to do now from a privacy point of view. So Flick and Paul, what notifications or public statements should be made, and what do you really need to be careful of? I suppose we're looking not only at existing customers, but equally any end users and employees. So who wants to start?
Yeah, I'm going to pick up on the customer piece, and I think Paul's going to do what additional notifications you might need to make to underlying data subjects. So I think that the sort of high level point or takeaway here is that you should exercise some caution regarding any statements, assurances or promises that you may make publicly regarding your plans for the data. You've got to keep in mind that those plans are likely to change over time, and so you don't want to make public statements that would limit what you can do in the future. Think about the issues that WhatsApp and Facebook had on this particular point. So I think any public statements or customer communications should be carefully vetted with the privacy team to ensure that they are accurate and lawful and not going to restrict what you can do as a business. Now, in terms of the notifications that you need to make to customers, really it's really going to depend on the role that the companies are going to play post-acquisition. So if, for example, in a share sale, where obviously the target will remain as a company, it's just now a subsidiary of a new company, if the acquiring company, the purchaser, is actually going to start providing services to that target company, it may be that the purchasing company has now become a sub-processor to the target. And so you would need to check that the target's customer terms and make sure that in that agreement you haven't, you comply with whatever notice obligations you've committed to around providing information about changes to the sub-processors. Now, just a reminder that Article 28 of the GDPR basically says that if you're a processor, you're contractually required to provide prior notice of any sub-processors that you use. And if you're relying on a sort of general consent from your customers to use sub-processors, you have to go provide them notice of any changes to those sub-processors and give them the ability to object. So you need to have some thought to whatever you've agreed to in the customer contract in that sense. In the context of an asset sale, so if the purchaser is going to become the new processor of all of the personal data for which the target currently acts as a processor, this is going to require notification to the customers as well. Again, you'd have to look at what the customer terms state. And then the other point to flag is if you, the purchasing company, are now also going to use the target to provide services to you, you may also, as the purchasing company, notifications you may need to make to your own customers around any changes to the sub-processing arrangements.
In relation to public statements and customer communications, I think the acquisition of Yahoo by Verizon is a very good illustration of the need to consider privacy and cybersecurity before any deal is announced. So you may have heard back in July 2016, you had Verizon who announced their plans to buy Yahoo's internet business. And it was only after the deal was announced that Yahoo announced that they had discovered 2 data breaches in 2013 and 2014, affecting more than 1 billion user accounts. And this unexpected breach led to the sale price to be reduced by $350 million. It caused significant delays in closing the deal. And the liability did not end there, because after the deal concluded, Yahoo's successor entity was ordered to pay $85 million to settle a class action. They were subject to FTC remediation measures. Yahoo's board said they would not pay an annual bonus to Yahoo CEO for 2016, as well as a 2017 equity award. And more interesting for the legal department, Yahoo's general counsel left the company as well. And the board's independent committee investigating the hacks said that, I quote, "The relevant legal team had sufficient information to warrant substantial further inquiry in 2014, and they did not sufficiently pursue it. As a result, the 2014 security incident was not properly investigated and analyzed at the time, and the company was not adequately advised with respect to the legal and business risk associated with the 2014 security incident." So, this is particularly interesting because, it shows that the legal department has, a vital and crucial role to play in relation to cybersecurity. And, back to the M&A perspective, it shows, how important a comprehensive due diligence process needs to be, how important it is before any deal announcement is made. And here is another example to consider. Back in 2017, so not that long ago, the European Commission fined Facebook 110 million euros for submitting incorrect or misleading information about plans for its WhatsApp acquisition. So what happened was that at the time of the acquisition in 2014, The company told the EU Commission that it would be unable to link Facebook users' accounts with WhatsApp users' accounts. However, in August 2016, WhatsApp announced that they are making updates to their terms of service and their privacy policy, including the possibility of linking WhatsApp users' phone numbers with Facebook users' identities. And naturally, the European Commission, when they found out about this, they were unhappy. They said that this was contrary to Facebook statements back in 2014 during the review of the merger. And the European Commission also said that the technical possibility of automatically matching Facebook and WhatsApp users' identities already existed back in 2014, and that Facebook staff were aware of such a possibility. And that's the reason why they imposed this fine of 110 million euros on Facebook. So the case is interesting from a legal point of view because it's the first time as well that the European Commission imposed a fine on a company for providing incorrect or misleading information in relation to a merger announcement.
Yeah, and I think so. And just to go back to the question around what notification needs to be provided to individuals. Actually, this is going to depend on whether we're dealing with an asset deal or a share sale. So in an asset sale, obviously what happens is that the data is effectively transferred to a new entity, which becomes the new controller of the information. And so you would need to provide information to the underlying individuals, ideally no later than at the time of transfer, unless, that's going to involve disproportionate effort, to let people know about the identity of the new data controller and to inform them about that data controller's privacy practices, i.e. to give them information about their privacy notice. And in some cases, you might also need to give those individuals the right to opt out of their information being shared with that particular, the acquiring company. So, the French and German regulators have previously provided advice that, insisted that there was advance notice provided to data subjects and that they were given the ability to object to that transfer of data to the new purchaser. And then in a share sale, if the acquiring company is now going to want to benefit from all this new data that sits within the target company, you may also need to provide notice about the fact that there's now a new recipient of the information. And so you need to check what the privacy notices of both the target and the purchasing company say, to check whether or not they would cover a transfer of data to the acquiring company, and it may mean that the acquiring company needs to provide notice of the way in which it intends to use the data that it now has access to, and update its privacy policies to reflect any new use cases. And equally, the target will need to just check whether or not its current disclosures around the recipients of data would cover, data sharing with the new affiliate. And then if you're going to be using the information between the two companies for new purposes, then again, that may force an update to the privacy notices to reflect the new additional use cases that, new purposes for which the data would be processed.
So talked about sort of notifications. Paul, what other key actions need to be prioritized in the immediate aftermath of a closing? What should you be considering from a privacy perspective?
I would say that it's important to consider if new or updated data transfer agreements should be put in place to reflect how data will be shared between the companies post-closing. So in the cases where the target company's products, services, or websites are being integrated with those of the acquiring company, as opposed to maintaining them under separate bands, it is likely that the privacy and the cookie notices will need to be unified. The new consolidated privacy notice should cover all of the data processing that takes place for both entities. And likewise, cookie notices may need to be updated to include notice of the additional cookies used by the target company. Don't forget the Privacy Shield certification update as well. Under the Privacy Shield supplemental principle on self-certification, an organization that will cease to exist as a separate legal entity following a merger or a takeover must notify the US Department of Commerce of this change in advance. As a side note, I wanted to mention, a recent development since we are on a live webinar as well. So you had the US Federal Trade Commission, which announced just 2 weeks ago that they had taken action against the company, claiming on their website that it participated in the Privacy Shield framework, even though that company did not complete the steps necessary to be certified as compliant. So this is another great example of how important it is to ensure that your website is accurate and always up to date. Don't anticipate and make an announcement, or even not necessarily even an announcement, but don't include in your privacy notice something which is not yet accurate. Wait for the certification to be complete, then you can put it on your website. And just another example as well, in the same on the same date, the FTC also sent out. They say that they sent out warning letters to 13 companies that claim that they participate in the safe harbor frameworks. So for those of you who don't remember, the safe harbor framework was the predecessor to the Privacy Shield framework, and it's no longer enforced. Again, these enforcement actions show that it's always important to ensure that your website, your documentation remain accurate and up to date.
Great, thanks, Paul. So we talked about various things, but when you acquire a company, specifically by way of a share sale, you'll no doubt inherit a number of vendor agreements. So Flick, how would you approach these from a privacy perspective?
Yes, good question. So hopefully during the due diligence stage, you did a thorough review of what the target company, what existing vendor agreements the target company has. And so hopefully, if everyone's done their job in the due diligence stage, then you have some kind of list of what vendor agreements are, what current vendor agreements the target has. And then it's really a process of going through those vendor agreements and making sure that they address the GDPR requirements, that they include appropriate EU data transfer terms, and then also to have some consideration for whether or not that vendor post-acquisition will actually be providing services now, not only to the target, but to the the purchaser as well. And so you might need to go back in and just check whether or not you need to make any updates to the existing vendor agreements to assess whether or not they need to be extended to cover affiliates, whether they need to be updated or renegotiated to address any deficiencies from a privacy perspective. And then if there is any overlap in the vendors used by both the target and the buyer, then actually it may be more appropriate to consolidate the agreements moving forward, if the services are going to be provided to the new group as a whole. And then if any of the, and likewise, you should just test as part of your review of the vendor agreements that the vendors can actually provide appropriate security. So what security due diligence was done on those vendors when the target initially signed them up, and then that will be important if moving forward that vendor is also going to be providing services to the buyer. If you are the buyer as well, you may need to make sure that your own vendor agreements cover or would allow the target to use any of the vendor services if you want to extend out and ensure that moving forward your existing vendors will provide services to the target. And I'm thinking more around sort of hosting services. So if you're using one hosting provider as part of your integration efforts, you might want to move everybody over to the same hosting provider. You need to make sure that your contract allows for that.
Thanks, Flick. So we've touched on this briefly, and I think this is probably a key question that the purchaser will be considering. How can they use their acquired company's data for its own business's purposes? So like marketing, product development, et cetera, et cetera. That's probably one of the key things they're wanting to do with the data.
Yeah, good question. So it's all very exciting post-acquisition. You've got this new company and everyone, especially your marketing team, start rubbing their hands with excitement that there is all this potential marketing data that they could do lead generation on. Or there may even be really useful product information or service related data that's been collected that they can generally be used by the group to improve its products or identify upselling opportunities, etc. So one of the things that you have to be cognizant of is this, the purpose limitation principle. That's really a core principle in European privacy law. And it basically says that data must only be used and processed for specified, explicit, and legitimate purposes, and it can't be processed in a way that is incompatible with those purposes. So if you now want to use the target's data for certain purposes as an independent controller, you need to make sure that whatever the purposes for which you want to use it are compatible with the purposes that are being communicated to the data subjects, and that there has been sufficient transparency to support your use of that data for those particular purposes. If it's not a compatible processing purposes, or it's something that the individuals are unlikely to expect or would be outside of their reasonable expectations, or it's going to have an unjustified impact on that on the underlying individuals from a privacy perspective, then you're going to need to go out. Potentially, you may need to go and get consent from the underlying individuals to be able to use the data for those new purposes. And then the other thing to flag here is that if the target has positioned itself as a processor of lots of this information, and I'm thinking more in the context of delivering its services, and now you as the purchaser actually want to use this information for your own product development, upsell, etc., and you'll become a controller of that information, then you may not have, and the target may not have gotten the necessary permissions as a processor to enable that data to be used by you as a controller, and that is permission from the customer. You'd separately also need to consider whether or not you need to get permission from the underlying data subjects. But it's really important to really scope out and test, do we have permissions with the customer if we're a processor and now want to use it for new purposes as a controller? Do we have the necessary transparency and legal grounds if we want to use it as a controller vis-a-vis the underlying data subjects? And from a marketing perspective, if you're now looking to sort of merge your databases, and the purchasing, the buyer wants to now use the information that the target originally collected for its own marketing purposes, so there's all these new lists that it can now utilize, you need to test whether or not the original grounds on which the target was relying on to use the data for marketing purposes can actually enable you as the buyer to do your own independent marketing. And it's unlikely that, if you apply some of the stricter tests that will be applied if you follow the European marketing rules as set out in the e-privacy directive, that you've automatically got the necessary permissions to go and do that marketing. And so you might have to take a bit of a risk-based approach there and consider what steps you might need to take to try and defend your ability to use that information to market to the target's own marketing list. And you also would want to do some kind of hygiene check of the existing marketing information that target has. So screen it against your own opt-out suppression list to check that these are individuals who have not already opted out from marketing from you guys. Check how old that marketing data is that the target has been using. Is some of it old, outdated, inactive, and therefore if you start to use it, it's going to increase your compliance exposure, because people will really be surprised to hear from you in the first place, and secondly, it will come out of the blue because that target hasn't even been marketing to those people in years. Check the source of the marketing data. Was the target relying on third-party data? So there was already a risk in them using that information, and now there's an additional risk because you are now attempting to use that information for your own marketing purposes. So there was no real transparency provided to the data subjects in the first place. So you really need to be very careful about sort of just thinking you can dib into the shared now database and use that data as the buyer for your own purposes, without really thinking through, do we have legal grounds, have we provided transparency, or even do we even have the necessary permissions because we're just a processor of that data vis-a-vis our customers.
Cool, thanks Flick. So I know we're starting to run out of time, so my last question to wrap this up is, Paul, what other privacy compliance actions will need to be addressed post-closing to integrate the purchase target with the buyer's company?
Thank you. I'll be quick then, since I'm conscious of time as well. So the first point is to ensure that the complete list of all vendors engaged by the target company is made. And, you need to identify as well, the role that each are playing, controller versus processor. So you need to such a list. You should also have a copy of all the existing vendor agreements of the target company. And those vendor agreements should be reviewed and updated as necessary. For example, to ensure that they include terms which are mandated by the GDPR and other applicable privacy requirements. It may be useful and appropriate to consolidate the agreements moving forward, or otherwise to verify that they cover, for example, the acquiring company's affiliates. And then you should have data maps and Article 30 processing records, which are updated to ensure that they fully reflect and document the target company's data processing activities.
Awesome, thanks, Paul. So I just want to say thank you to everyone for joining us this morning. As I mentioned at the start, if you do have any questions, please send them through and we will definitely follow up with you each individually. Other than that, Flick or Paul, any closing comments?
Yeah, I mean, I think we covered some of the key stuff, but there are plenty of issues to consider here, and we've given a sort of high-level overview of lots of the stuff to consider. But as Joe mentioned, if you have any follow-up questions, please do reach out. We'd be happy to chat through in more detail some of the issues that you might be grappling with in an M&A context.
Great, thank you, everyone. Have a great day.
Thank you.
Thank you.